All right, good afternoon, everybody. Thank you for attending today's session on evictions. Just a couple things before we get started. Please keep your microphones and your cameras off during today's presentation. Also, if you have questions, please type them in the chat box and I will relay them to our presenter at the end of today's session. Also, if you need a certificate of completion, please email Stacy after today's presentation and she will get that out to you. So with that, I will turn it over to Christina, and she's presenting on evictions.
Thank you. This has been a couple years now since I've had the pleasure of doing this. So hopefully for those of you that have seen this before, this is a nice refresher for those of you who have now first attending this and seeing it for the first time. Hopefully this information will give you the basics of what we would expect or what you might want to see with regard to eviction proceedings, at least in the state of North Dakota. My name is Christina Wenko. I'm a practicing attorney at Makoff Kellogg Law Firm in Dickinson. I've been practicing for about 10 years now. We do a lot of evictions for landlords and property units in the Southwest area, specifically in Dickinson. We also do a little bit of work in Watford City and in the Williston area as well. So hopefully, like I said, this will be a good baseline for most of you. And again, I will be happy to take questions at the very end. So let's start with the basics. And the basics of what we're talking about today is simply what is an eviction? And it is the legal process that we use to recover the possession of real estate. There are multiple situations that would require an eviction, and the statute in North Dakota in the Century Code, it's very specific as to what those eviction requirements are. So you can proceed with an eviction when a party by force of intimidation, fraud, or stealth has entered upon the prior actual possession of the real property of another and detains the same. Very rarely does that one happen, but it does and can happen. Number two, a party after peaceably entering upon real property turns out by force, threats, or menacing conduct the party in possession. Again, that one doesn't happen very often, but it certainly can. Number three, a party by force or menace and threats of violence unlawfully holds or keeps the possession of any real property, whether the possession was acquired peacefully or otherwise. Number four, a lessee in person by or person by subtenant holds over after the termination of a lease or expiration of the lessee's term or fails to pay rent for 3 days after the rent is due. This is the one that applies to 99% of you. This is the one that we deal with in a specifically a landlord-tenant type of situation. There are some other examples. Number five being a party continues in possession after a sale of real property under a mortgage execution order or any other judicial process. This would be an example if there's a foreclosure and the bank is to receive the property back and the tenant has not, or the mortgager has not vacated at that time. Number six, a party continually wrongfully in possession after a judgment in partition or after the sale under an order or a decree of the district court. Number seven, a lessee or a person on the premises with the lessee's consent acts in a manner that unreasonably disturbs other tenants' peaceful enjoyment of the premises. This is probably the second big one when it comes to what you all may be facing with regard to your management responsibilities. This sort of goes hand in hand with what some of you may already have in your existing lease agreements. But this would, again, provide if you have an unruly tenant or if you have someone that's, again, causing or disrupting someone else's peace and enjoyment of the premises. And number eight, the lessee violates a material term of the written lease agreement between the lessor and the lessee. And that's another big one. Some of those might be smoking, pets, things of that nature. But for the purposes of this proceeding, we're going to focus on failing to pay rent on time. You use the process in a manner that unreasonably disturbs others' tenants' peaceful enjoyment of the premises. And number three, the tenant violates material term of the written lease agreement. So let's talk about the first one. The first one is the failure to pay rent. This is the most common reason for eviction. Again, it it transpires when you have a situation where there is a lessee who holds over after the termination of a lease or expiration of the lessee's term, or fails to pay rent for 3 days after the rent is due. Again, the most common type of evictions that we have. So what you want to do is you want to make sure that you're checking your lease for penalties for failure to pay timely. Does your lease provide for late fees in the event that someone is failing to pay on time? And you also want to check your leases as well, because the terms can vary quite substantially from lease to lease. And also you want to make sure that your lease does or does not require a certain notice period before an eviction can be commenced. By statute, the law says, the Century Code says that you have to give a 3-day notice to quit. Now, sometimes a lease may say that you have to give a 7-day notice. I've seen some where they say you have to give a 30-day notice. So whatever it says, you just want to make sure that you have read it and you're in compliance with it in the event that you're giving a notice that someone's in default for failing to pay rent. And if so, what is that requirement for being in compliance, or is there a notice period that's beyond the 3 days? Because if there is, you want to make sure that you're complying with the lease agreement as to what it specifically says. Let's talk about the second one, and that's disturbing the peace. That is a situation where a lessee or a person on the premises with the lessee's consent act in a manner that unreasonably disturbs the other tenant's peaceful enjoyment of the premises. You want to make sure that you have a kind of catch-all provision like this in your lease agreements, because again, if you had a situation where you were having an unruly tenant that was continually having parties, loud parties, you have loud music, you're fighting, you have erratic behavior. Sometimes we see situations where there's domestic violence potentially, or there's, fighting between roommates, things of that nature. This is kind of the good catch-all provision that would allow you to bring an eviction if one of those provisions are met, or you find that the tenant is engaging in this type of behavior. And finally, the material breach of the lease. This is when a lessee violates a material term of a written lease agreement between the lessor and the lessee. Again, as standard common practice, you want to make sure that you have this catch-all provision in your leases most of the time that you do, but again, it doesn't hurt to make sure that it's in there. Some of the examples that you might find here are smoking, the cleanliness. If you've got like a hoarding type of situation where it's causing, probably sanitary concerns. You've got upkeep of the property, where if someone is required to be maintaining certain areas. And then, of course, if you have illegal activity on the property, drug use, if you've got someone coming in and out all terms of the night with, engaging in criminal behavior, those are grounds for bringing an eviction based on this material breach of the lease. So again, you just want to make sure that you have all of those specific requirements listed in your lease. For example, there's no smoking, there's no pets, there's, the property must be maintained in a certain cleanly order, and you must upkeep the property. And then, of course, you have no illicit or criminal activity associated with the property or on the property while the tenant's in possession. All of those things are really important to make sure that you have in your lease agreements, because if you need to rely on them later pursuant to this provision of the Century Code to get an eviction, you need to make sure that it's already in there. Okay, so let's talk about what the process is for the actual eviction. So step one is to send a notice to quit to the tenant. And in that notice to quit, you must identify and determine the violation. And you would secondly send that notice to quit or the notice of intent to evict or termination of lease. And the purpose of that document is threefold. It is to inform the tenant there is a violation, to inform the tenant that the landlord is proceeding with eviction, and to inform the tenant that the lease is not being renewed. Now, depending on whether the tenant vacates, determines how far you have to get into the eviction process, but it is simply telling them, hey, you've got 3 days to, vacate the premises. If you don't, then we will be proceeding with the eviction process. Once that notice is prepared, that notice must be personally served on the tenant. We recommend that notice be served by a third-party process server, and you have to have a return of an affidavit of service. In fact, the Century Code has gone a little bit farther to say that it requires third-party service. So I've had prior clients who have someone within their organization go over and serve those notices. I do not recommend that. Typically, if my clients have done that in the past, we send somebody else over there as an independent third party that can sign an affidavit attesting that they have personally served or posted the notice on the property. And this is, again, to put the client or put the landlord in a non-biased situation where we're not having to testify that we are in fact the individual that went and served the notice. We can put that responsibility on a third party. The notice provides that a tenant is instructed to vacate the property. You must be given 3 days notice before the landlord can proceed with eviction. So hence the 3-day notice to quit. If the tenant does not vacate the premises within the 3-day statutory requirement, then the landlord is then free to proceed with the summons and complaint. What does the summons complaint entail? And that's the second major step in the process. Essentially what it's asking for the court's approval and action for the removal of a tenant who will not vacate. The summons is the document that informs the tenant of the time and the place of the hearing. The statute in North Dakota is very specific as to when that when the summons must be served. The summons may not be served no fewer than 3 days prior to the hearing, but no more than 15 from the date that the summons is issued. So if you get to this point where you are required to serve the summons and complaint, you need to make sure that you are abiding by those deadlines and that your process server is not serving it too early or too late, because that can be a reason why you get an eviction bumped or dismissed because you've not met the statutory requirements for the notice. The complaint will outline the reasons for the eviction and it will generally mirror what was already in the notice to quit. Both of these documents, the summons and the complaint, must be personally served on the defendant. If the tenant cannot be found, the documents can be posted after service has been attempted at least once between the hours of 6 p.m. and 10 p.m. And this is because tenants duck eviction service. It's not an uncommon thing where you may not come to the door or you choose not to be home at a certain time. So this is a allowance for allowing the process servers to get around the personal service. So you either personally serve it or it's posted, but it has to be attempted before it can be posted. Again, we definitely recommend that a third-party process server do these postings. That can be done by a sheriff's office or a private process server. And you must have an affidavit of service or an affidavit of posting from your process server or your sheriff's department. This is the documentation that the court is going to require to ensure that you have given the tenant the proper notice requirements of the summons and complaint. When we get to that part of the process where all of those documents have been served and we're getting ready to file with the court, the service documents must be filed with the court along with a copy of the notice to quit and the summons complaint, as well as the lease agreement and any other relevant information. If there's an amendment or some sort of attachment or something, like a tenant's rules that they have to follow that might be applicable to the reason why you're evicting this person, all of that necessary information should be filed with the court prior to the hearing. Step 3 is the actual hearing process. I would say it's probably 50% of the time where tenants simply don't show up. And if they don't show up, the landlord is going to obtain a default judgment. It's basically saying, you're going to get whatever you've asked for as far as your remedy, and that may include immediate possession of the premises, as well as a judgment for fees and costs associated with the eviction, as well as back due rent. If the tenant does show up, the landlord is in a situation where they're going to have to present evidence supporting the reason for eviction. And this may come in the form of testimony from the landlord or the property manager. It'll come in the form of a lease agreement that would be submitted as evidence, past due balances, a ledger for the landlord, and sometimes photographs if we've got a situation where the tenant is engaging in unruly behavior or putting holes on the wall or whatever the case may be. You're going to want to make sure that your attorney or you as the landlord, if you're showing up pro se, have all of that information in hand at the time of the proceeding. The tenant has an opportunity to testify at those proceedings. The tenant is precluded or prohibited from raising any counterclaims except as a set-off to demand for the damages or rents or profits. And the reason for that is an eviction from the eyes of the law is a very narrow process, and we don't get involved with everything and anything. What we're talking about is what's at issue, and that is, has there been a breach of the lease? And if so, what is that breach? And is the landlord entitled to a remedy in the form of money or in the form of possession of the premises? We're not going to sit and talk about, an issue that the tenant had, 7 years ago. The judge isn't going to get into that, and it's very limited. So the judge will issue the ruling on the eviction, and usually, and a lot of times, what will have happen is, let's say the tenant shows up, and we may not have a situation where I even put my client on the stand. We'll simply say, Your Honor, the tenant is here, of course, understanding, does the tenant agree with the eviction? And usually, I would say a good majority of the time, the tenant will say, yes, I'm behind, but I would like, a certain amount of days to vacate the premises. Or maybe there's a slight disagreement about the amount that's due and owing. So you might get through the process, and you might not have to have a full-blown hearing where you put your client on the stand. But it just kind of depends on the response that you're going to get from your tenant. So step 3 in that process is getting the decision from the court. And if the court finds for the landlord, the court shall enter a judgment for immediate restitution of the premises. There is one exception. If the tenant can demonstrate that immediate restitution would be a substantial hardship, the court may grant up to 5 days to vacate the property. This is statutory, which means that the court cannot go beyond this unless the parties were to agree. Now, there is an exception, is if the eviction is for disturbing the peace, immediate possession of the premises is granted. But if someone came in and said, I know I'm behind, I need to get out of the property, would you give me 5 days? The court can grant the 5 days. If the tenant wants more than 5 days, then the landlord would have to agree at the hearing to allow more time. And then, of course, eventually the court would issue the judgment for eviction, and the judgment for eviction would include any past due rents, late fees, if there are other types of fees associated with the eviction process, attorney's fees, if your lease provides for it. You can only get attorney's fees in the event that your lease, again, provides for attorney's fees. So eventually the court will issue the judgment for eviction. Now the next step. So usually, I would say 90% of the time, once the tenant gets served the judgment for eviction, or they attend the hearing and they know they're getting evicted, they vacate the premises. But there are those times where those tenants do not vacate the premises. And that's where we have to take an extra step. And that requires a writ of eviction or a writ of execution. And if the tenant does not vacate within the time specified by the court in the judgment for eviction, the landlord must obtain a writ of eviction. And that writ of eviction is actually issued by the county clerk of court's office based on the judgment that the court issues. And this must be executed by the county sheriff's department. They are the office that has the authority to do this. So if you do get a writ and you do have to have someone physically removed, it's the county sheriff's office that will be involved in that process. And most of the counties have a civil process unit that deals specifically with this and this only. But again, you should check with your county to make sure, but Normally, like I said, it's going to be your sheriff's office that are involved in these types of proceedings. A couple of special considerations. Do not, as landlords, employ any self-help methods or remedies. I will say that again. Do not employ any self-help methods or remedies. You cannot change the locks. You cannot remove any personal items. You cannot do anything that would be to the detriment of the tenant prior to obtaining an actual eviction. And you can get into some serious trouble doing this. You can also be responsible for treble damages, which is 3 times the amount of damages. So if you're having an unruly tenant, my recommendation is that you proceed with the process, you get that writ for eviction, and then you proceed to getting them removed by the sheriff's office. You don't want to have a situation where you have, like I said, changed the locks or done anything like that. That's going to be really bad news for the landlord. So just don't do it. Another thing that is always very helpful for the landlord is to make sure that you're documenting all of the communications with your tenants. Text, emails, notices, making sure that you've got a full record of what was said and what was not said. You know, the last thing that we want is for a client, a landlord, to be on the stand and say, you know, I gave him this notification, or I talked to him about this, and then tenant gets up there and says, that never happened. Okay, well, who do we believe? And so you can avoid all of that by simply putting all of that information or all that documentation in writing to your tenant. Again, text, emails, notices, best way to do that so you've got an adequate record in the event you found yourself in a situation where you were in court and needed to proceed. Just another thing I'll touch on very briefly is service animals. This question kind of comes up a little bit. Service animals by federal law are not pets. And the Federal Housing Association does not require a service animal to be trained or certified. So you have to evaluate a request for a reasonable accommodation, and you have to determine, does that person have a disability? And is there a disability related need for the service animal? You have to, or you have the ability to factor in the direct threat of harm to others. And you cannot require a no pet deposit for a service animal. And you do have the right to ask for documentation if a disability is not readily apparent. And there is some distinction between service animals and emotional support animals. Federal law, I just looked at this the other day, and actually by federal law, service animals are only defined as dogs and mini horses. I don't know how you arrive at the mini horses situation, but that's what it says. Emotional service animals or emotional support animals has a wide variety. And North Dakota is kind of taking a you know, kind of a same or similar approach to emotional support animals as they are taking to service animals. So again, you do have the ability or the right to ask for documentation if necessary. So, you know, cross all of your T's and dot your I's when it comes to that. And you can ask for, like I said, information to support the tenant's request for a said service animal. So, okay, that is the shortened version of it. So I would be happy to answer any questions that anybody has with regard to the process. And feel free to hit me with questions.
So far there's one. I have a weird question. I have a client with Section 8 choice voucher. The landlord moved to Washington and the tenant was served notice from North Dakota Finance that she will have to leave eventually as no one has been making house payments. Landlord will not answer me by email, text, or call. What resources does my client have at this point? Recourse does my client have at this point?
So your client's the management company that's got the landlord or the owner of the property not responding? Is that what I'm hearing?
It's a personal landlord and the client is the tenant.
the client is the tenant. I guess, can you read that one more time, Kylie? I'm not following the question.
Yep. I have a client with Section 8 choice voucher. The landlord moved to Washington and the tenant was served notice from North Dakota Finance that she will have to leave eventually as no one has been making house payments. Landlord will not answer me by email, text, or call. I don't know if I keep sending the payments. It's a personal landlord. They used to live there and the client worked for her.
So the landlord owes the payments. You know, as far as be concerned, I would say that that's probably a more private action with the tenant. If the Section 8 housing isn't going to be maintained because the landlord isn't making payments, you know, that's an issue with Section 8 and the landlord. As far as the client living in the premises, there's probably not a whole lot you could do about that, to be bluntly honest, because that's a civil issue between the other two parties, obviously being affected by it. But I would say that you're limited, your likelihood of any sort of action there as the tenant is probably pretty limited, given the circumstances surrounding the relationship between the other two parties, unfortunately.
Would the tenants have any legal recourse if the landlord does not keep the property up to the housing habitability standards?
Usually, it's important. I think the century, we don't deal with this one quite a bit, but there are some requirements, obviously, for a tenant or a landlord, excuse me, to maintain a habitable premises. And that's the responsibility of the landlord. So if you are in a situation where you're not in a habitable unit, you can potentially bring an action against the landlord. The other thing that you can do as a tenant, I mean, sometimes, and this does happen because it's happened to me, I've had known about certain circumstances where tenants have actually called into the State Board of Health and made a notice to them that they have a unit or they're living in a place that's uninhabitable. And so if that's the case, then sometimes the municipalities or the counties may get involved to determine whether that is in fact a habitable unit. But the tenant can certainly bring forward a cause of action to the landlord or against the landlord if the premises is not habitable. Now, to be uninhabitable, it has to be really, really bad. It would have to be no heat in the winter, no plumbing, something really, really bad to make it uninhabitable. If your stove is broken for 2 days, it's probably not going to foot the bill. So you'd have to, it'd have to be something pretty significant.
If someone is on month to month, is it still 30 days notice to have them leave? Since it's month to month, landlord does not need a specific reason to have the tenants leave, correct?
Yes, so that relates to a situation where you're just talking about the termination at the expiration of a lease term. That's not talking about the eviction process, but yes. So if you are on a month-to-month tenancy, you must give a month's notice before you seek to terminate that lease. And that's required by statute. So if you are, again, once it converts to a month-to-month, that 30-day notice has to be given.
If you communicate via USPS, do you recommend a certified letter with return signature?
It's not always required, but it's not a bad thing. You can always, document or take a copy of whatever it is that you sent. If you're talking significant notices of default or violations, I would certainly recommend it. That way you can document again that you sent it. And also too, if they're not signing for it, depending on what it is, service requirements allow you to send it certified mail return receipt requested. And if it's denied or not signed for, then that can in some circumstances constitute service. So it's not a bad thing if you need to do it. If it's a simple notice to let them know that they need to, do this, that, or the other, it probably, isn't worth it to spend the money to do it. But if we're talking significant notices of default or something else of that nature, it's always better to err on the side of caution and do it rather than wish you had done it and have some way, shape, or form it comes into question about whether service was actually completed or notification was actually given.
If a notice to quit has been sent, tenant promises to move out but needs a couple extra days, this is agreed by both parties, then tenant says they are moving and will be out by noon on the final day, asked to be allowed to extend till 3 p.m., has been informed by landlord and agreed to landlord changing locks at 4 p.m., then does not move everything. Can locks be changed and tenant allowed in during landlord's working hours to remove the rest of their belongings when tenant agreed to this without repercussion on landlord? So it's a long one.
No problem. I get the gist of it. My recommendation in that situation is to err on the side of caution and proceed with the actual judgment for eviction. And here's why. If you have a tenant that says, yeah, I'm going to get out, I just need a couple extra days and this, that, and the other, and that just keeps going and going and going, you need to have that written documentation so that there is no question. So in a situation like that, I would say to my client, if they're not out and you've given them one minor extension and they're still not out, then we need to proceed because that can be a snowball effect where they may not vacate, or there's this understanding about how they were going to give them more time and maybe they, didn't get all that time, and then it becomes this giant mess. So you can certainly be workable and agreeable to some certain alterations, but at some point, if the tenant is kicking the can down the road and you're, 5-10 days after the notice to quit and they're still not out, still, begging for time or giving excuses or this, that, or the other, the best course of action in that situation is simply to proceed and secure the judgment. Because if you wait too long between when the notice is served and when you proceed with the actual summons and complaint, I've had situations where I've instructed my clients to start the process over because of that delay between when the notice is served and when the summons complaint is actually proceeded with.
Can a tenant seek to terminate a lease due to landlord not fulfilling their responsibilities, such as not providing maintenance, fixing things, etc., and still receive their security deposit back?
It's possible, but that's not an eviction type of action. That's a civil action between the landlord and the tenant for a breach of the agreement. And that would depend on whether you've got a case or not, I guess, but that would fall outside the parameters of a eviction. That's a civil action between the landlord and the tenant.
So to kind of go along with the deposit, hold on, I'm reading this quick. What does the landlord need to provide as proof for them to not get their deposit back?
So when you initially rent, you sign that lease, usually most of the tenants most of the landlords will go through some sort of checklist of some sort where you go through and you do a walkthrough of the premises or the property and say, here's what condition it is. The landlord has the ability to withhold the security deposit for unpaid rents, damage to the premises, but it has to be itemized, and that usually has to be given back to the tenant in some sort of, like I said, itemization to show what is actually being withheld. And 9 times out of 10, when you're dealing with an eviction, if it's rent-based, that security deposit's usually being held for back due rent, or if it's, you know, like I said, damage to the unit, things of that nature. Those things will warrant the retention of a security deposit.
If a landlord doesn't make a repair, can the tenant hire a person to do it and provide the receipt instead of rent that month?
I would say probably not, because your rental obligation is contractual and you are required to pay that pursuant to the terms of the lease. If you have a situation where, you know, I can't imagine a lot of landlords would be open to the idea of having someone else come in and complete the repair and then they pay them for that. Most of these companies or management companies, in my experience, have a landlord or have some sort of individual, like a maintenance person on staff that does this stuff. But you are not in a situation as the tenant to unilaterally say, I'm not going to pay my rent this month in lieu of paying for this, that, or the other for a maintenance repair. That would not be, in my opinion, appropriate. So you'd still make your rental payments if then there's a situation with something that needs to be fixed. That's a separate issue with your landlord. Because you can get in just a hodgepodge of this, that, or the other with a landlord, and it's just not worth it. So I would say you just make the payment as is and then proceed with working out the repairs with the tenant or the landlord.
If a tenant leaves the property and has left possession or personal items behind, how long does the landlord have to, is there a time frame where the landlord has to keep it before either destroying it or selling it?
Yes, statutory requirements are 28 days. So if you believe that the value of the property is roughly less than, I think it's 2,500-ish, that you have to store it for 28 days. After that time frame, or if the value of that property exceeds that amount, the landlord is entitled to get a lien against that property. Usually, you know, depending on what's left in the premises, you're probably not going to reach that threshold of the value of the property. But again, it depends on the value of the property and what you have to do with it as far as disposition. But for example, if the tenant leaves a bunch of clothes, maybe some kind of junky items, maybe an old couch or something that you honestly believe wouldn't be worth $200, that stuff you have to hold and maintain for 28 days before you can dispose of it.
If they do move out within the 3 days, do you recommend continuing with the court process?
That's up to the landlord. And the main thing with that one would be is whether you want to proceed with securing the financial judgment for eviction. Because that, in that situation, you would have to decide whether you would want to do that or not. Because without that official judgment, you don't have a judgment for a monetary judgment. And there might be another reason too, where you may want to proceed. For example, maybe you're asking for damages because they destroyed the house. And the only way you're going to get those damages in the form of a monetary judgment is to actually proceed with the hearing. But that is completely up to the landlord. We have some landlords that will want to proceed and get that judgment. And we have others that say, you know what? The reality is, even if we got a judgment, we're probably not going to see any money from this tenant, and they may not decide to spend the money to proceed.
If someone is living in a home with the understanding that they are to care for the land and home, but are not doing so with no rent collected, how do you go about evicting them if they are not holding up their end of the agreement?
That's beyond the scope of this particular example. That's going to be a civil issue between those two parties. That goes beyond the simple eviction. That sounds to me like that's a contractual obligation where one party may or may not be in breach. And that could be a multitude of things that could end up in litigation for months. But that would be something, like I said, that's not right for a simple eviction. That's something much more.
What if what if an eviction notice is served for rent payment, but at the same time the tenant got the rent to pay? He struggled, oh, hold on. He struggled to get the rent because he has many children with him.
So you're saying did the tenant that you served the notice, but the tenant came due and paid up the rent?
Yes, I believe that's what he's asking.
Yeah, I mean, that's the tenant, or excuse me, that's the landlord's decision on whether they want to cease the eviction. You know, I've had clients do that. I've had clients say, no, we're done, pay us our back due rent and we want to terminate the lease. Bottom line is that's completely within the discretion of the landlord.
If a tenant has been evicted, had more damages than deposit would cover, can a landlord file for that former tenant's ND tax offset?
I would say that usually if it's a situation where and we've had to do this once or twice. If you've got a situation where you have a tenant and you, let's say you go and you have a judgment for eviction and you get a judgment for rents and you get a judgment for late fees and things like that. And then the tenant goes back in, or excuse me, the landlord goes back in and realize they just destroyed this place. That would require likely a separate action, whether that's in district court or small claims court, depending on whether you're representing an entity or not, where you'd actually have to go back in and get a judgment, another judgment for additional damages. And then at that point, you could seek to collect on that judgment, whatever that judgment would end up being. And the reality on these judgments for a lot of these tenants, for the landlords, you know, you may get a judgment, and your judgment may say that you're entitled to $5,000-$8,000. But the reality is sometimes those judgments aren't worth the paper they're printed on because you still have to collect on them. And that requires the tenants to have assets that are not already mortgaged or liened, or they have bank accounts that you're aware of. So you have to really practically think when it comes to the collection efforts on what might be, what your likelihood of success is. You know, some tenants will turn it over to like collection agencies or this, that, or the other. You know, those are certainly options too, but you have to be practical in your collection efforts because they may be more expensive than you don't want to spend good money to try to go after bad, meaning that you don't want to spend a whole bunch of money if the likelihood of collecting on that judgment is pretty minimal.
Is a 10-day notice, does the 10-day notice have the same concept as the 3-day notice?
Yes. You know, I think that you could always give a tenant more notice than is required. The quirky thing about that is the statute requires 3. And I actually had a judge once. We gave a 30-day notice to quit. And we actually had to do it again because the judge said, I need to see a 3-day notice. So could you certainly do a 10-day? Yes, but you might find yourself in a situation where you may have to do another 3-day. You could do more of an informal 10-day notice, I suppose, and then say, you know, listen, you know, if this isn't happening or you're not out, we're going to have to proceed officially, and that would be the 3-day. So you might be doubling up a little bit, but like I said, I did have a judge tell me that once, and we had to do it again. And normally, you know, giving the tenant more notice is usually a better thing, I thought anyway. But you know, the judge said, nope, I need to see a 3-day notice, so we had to do it again.
When excuse me, when non-renewing a tenant once a lease has ended, does any reason have to be given as to why? And is 30-day minimum required to non-renew a resident?
The answer to that, do you have to give a reason? No, I don't believe the statute requires that, but you do have to give the necessary minimum mandatory notice period. And if you're on a month to month, that's going to be the 30 days. So, you know, if you're choosing not to, you know, like I said, you have to make sure that you're giving ample notice. And I would recommend certainly sending it out so that, you know, you're definitely exceeding the 30-day notice. You're not getting close to that, to give your tenant ample opportunity to know that the lease is not being renewed.
Can a landlord file an eviction if there was no lease agreement?
Yes, that's basically kind of a verbal lease agreement. I have done a couple of those. Again, it depends on the circumstances of the facts of the arrangement between the landlord and the tenant. It can be done. I would certainly recommend for all the landlords listening that you have a lease agreement in place, but certainly it can be done.
Does a 3-day notice have to be sent via mail, or can it simply be taped to a tenant's door?
The 3-day notice must be personally served on the tenant, and it must be personally served within a certain time frame. And if and only if that tenant cannot be personally served at the residence after an attempt is made, then and only then can the notice be posted. So a notice to quit cannot be mailed. It has to be personally served. Now, personal service by the statute requires process server to physically serve or post it on the notice. So you have to make sure that you're abiding by the Century Code requirements. But a process server or sheriff's department is going to be the best way to go with that.
If an individual gets a 30-day notice to vacate for non-renewal, but then gets water and electricity shut off with no notice on the same day they get the notice and is still living there, is that legal? Are they able to do this?
I would say that would be very unusual. You know, just because you get a notice, you still have 30 days to remain in the premises. So for someone to shut off water or do something like that, that would be highly unusual. Only when the tenant is fully vacated after the 30 days, I would say that would probably be allowable. But even then, that gets back to the situation where you're a holdover tenant. And if the tenant is a holdover, then you still have to proceed with the eviction proceeding. And as the landlord, you cannot do any sort of self-help remedies, and shutting off the water certainly would very likely qualify under that self-help remedy.
Lots of good questions. The tenants have a lease agreement. The landlord gave the tenants 11 days to leave because the landlord decided to rent to a couple with a child. Do they have to be out in 11 days?
I would say that it would depend on what notice requirements are in the actual lease, first and foremost. And then if it's got a tenancy requirement, if it is on a month to month, then you'd still be required that 30-day notice, in my opinion. So I don't think 11 days would probably cut it, but there might be some underlying facts there that would say otherwise. But typically, if you're going to terminate and that month-to-month tenancy is still in place, you're still looking at the 30-day notice requirement.
For PSH, does it require more documentation and violations against the renter to get them out?
PSH meaning?
I'm not sure.
I guess I'm not understanding when they're saying PSH.
Oh, permanent supportive housing. For permanent supportive housing, does it require more documentation and violations against the renter to get them out?
I guess I'm not familiar with that type of permanent housing. I've never had that come up before. But if it's on a lease, I would suppose my gut would tell me that the same requirements would apply. But I can't say for certain because I'm not familiar with that one.
What are possible ways to manage tenant appeals during eviction?
Um, a, a tenant appeals, I'm not sure what that all actually means, but, I think that, any internal process with a landlord, everybody's gonna be a little bit different on how they handle that stuff, but, um, again, I think it goes back to the documentation that you have with the communication that's being given to your tenant, so that you know what's being said and the tenant knows what's being received. You know, there are times where the tenant gets that notice and then they're calling you every other day, wondering what they can do about it. It's up to the landlord to determine what sort of, leniency or other steps that the landlord is going to take. But if the landlord decides, you know what, we're just done, we're going to proceed, the landlord has that right to. Just remember that, when you're dealing with tenants, be respectful, be professional, and document everything.
Okay, here's kind of a longer one. What if you have a solo tenant? So no other family, friends living in the unit. The lease is still active. So on a year lease, there are months remaining, but the tenant has been remanded to prison. Is the landlord required to leave the unit as it is until the lease expires, or is the landlord required to terminate via eviction? Or would this be an abandonment situation, so the landlord would need to store any property for X number of days?
Well, my thought would be is if an individual is now going to the federal penitentiary or prison, the likelihood of that individual remaining to pay rent is probably not pretty good. So if rent is not being paid, then you could proceed with an eviction for non-payment of rent. Then once you secure that eviction or that judgment for eviction, then it's a matter of storing that property for the required 28 days. And then, of course, after that, if you choose to decide to dispose of it, or if you knew someone else who knew this person and they wanted to come get the property and you made arrangements or something like that, you could certainly do it. But I would think that, like I said, if somebody is going to the state penitentiary or prison or whatever the case may be, they're probably not making rent payments. And that's the reason or the grounds for eviction.
All right, any other questions? If not, thank you again, Christina, for taking time out to present to our group. We had 104 on today, so that was huge. So lots of good information. And so again, if anyone needs a certificate of completion, please email Stacy, and she will get that out to you. And then also our survey will be sent out tomorrow morning. So if you can, again, just take a couple minutes to fill that out, provide any feedback or future topics for our trainings, that would be greatly appreciated. And next week is Halloween, and we have our presentation on ethics. So hope you all can join us next week for ethics. And thanks again, Christina. Hope everybody has a wonderful day. Enjoy the snow.